Or good evening or good afternoon, depending on where you are right now. And welcome to another edition of our Justice and Pieces guest speaker series. Today, we are joined by Marcus Sixta. He is a family lawyer, mediator, a former social worker, and he is the founder of Crossroads Law, a family law firm operating in BC and Alberta, and is also the founder of Coach My Case, a groundbreaking legal service company that aims to improve access to justice by providing remote legal coaches and paralegal navigators to those who cannot afford traditional legal services and are forced to represent themselves in court. So I'll leave you there to fill in a lot more about your background there. So Marcus, thanks again for joining us. And perhaps maybe we can start, you can tell us a little bit more about yourself, how you got into law and the number of things that you are doing.
Sure. Thanks, John Paul. So a little bit more about myself. I've got a background in social work. I was a social worker before I decided to go on to law school. And before that, I had a number of very random jobs and sort of didn't really know what I wanted to do. In law school, I focused on areas that I felt related to what I really was intrigued by and passionate about, including criminal law and family law. And the reason for that was because I noticed right off the bat there at the beginning of law school that I didn't really like working for sort of big entities. I liked working for individuals. I liked helping people, and I liked helping get through people through really difficult times in their lives. And so I focused on family law and on criminal law, and went on to article with the Crown's office in Calgary, and had a great experience there. I'd recommend to any students listening, if you are, it doesn't matter what area of law you're going into, articling at the Crown's office is a great opportunity because you get to try all these different areas of law on, and it's really hands-on as well, running trials in various different areas. And after that, the Crown's office, there was an opportunity to stay there, but I decided to go off into family law and joined a family law firm. And after practicing in family law for, I think, 3 separate firms, decided to launch my own. And 4 years ago, we started up Crossroads Law, and started that simultaneously in Calgary and Vancouver, and started with a team of 4 lawyers. And now we're up to 12, and we're looking for more. So it's been quite the journey, and yeah, we're looking forward to what's ahead.
Now let's go back there. Thanks for sharing all that, Marcus. So you mentioned you were kind of you were doing your social work there, and then you made the decision, like, I want to get into law. I want to go to law school now. Similarly, whether it's going into law school or some of my students, they're often are in a career and they decide, look, this is what I want to get into. I want to do law. What kind of helped you with making that transition and making that decision? And it's not always easy to kind of leave a career and go into something different. But what did you find help you, and what did you find kind of get you through law school in those initial times?
Well, I think that there's a couple of questions there. One is sort of what was the impetus for my decision to actually go into law? And then I guess the second part of that is what helped me get through law school. Well, the impetus to get into law was I wanted to be a change maker in society. And I felt like that was an avenue to do it. Social work had been great. And I felt like I was able to affect change and help people on the front line. But I knew that going into law, that there would be more opportunities to do it, because with a legal background, you can go into policy, you can go into government. There's a lot of different avenues that you can take, I think, with that knowledge. And so that was one of the reasons that I decided to turn my attention with respect to a professional degree towards the law. Getting through law school, that's a whole other complex kind of piece there. But for me, what it came down to was finding something I was interested in, because otherwise, I think that if you don't have something you're interested in law school, you don't focus on something. I don't know if you're as passionate as you need to be to really succeed. So that's why I focused in areas that I felt like I had a connection to and I was passionate about.
Now, speaking of your practice, I know, prior to the pandemic there, you took sort of innovative approaches in terms of, open concepts and flexibility to work from home before obviously working from home became kind of the norm, as well as things like being paperless. So can you tell us a little bit of some of those strategies there and the decisions that go into it and how it's worked for you? And especially now after the pandemic where everyone's kind of having to follow suit, what sort of made you thrive with doing those types of things?
Well, I decided I decided to be a paperless office for a number of reasons. One thing that became clear right away is that law firms that I was working in, they had vast amounts of paper and binders stacked up all over the places. And aside from just being unsightly and kind of nerve-wracking to be confronted with that kind of towers of paper all the time, it was an issue I felt like it was just creating a lot of waste, and I didn't really understand why it was necessary. And so we really wanted to early on focus on making sure that we were as paperless as possible. And that meant that unless something was required for court, we weren't going to print it, right? And everything was either scanned in or saved into the cloud. And we were cloud-based as well early on. And that way, you could also work from anywhere. If everything is scanned in and you have access to everything on your computer, I think that everyone now realizes that, but believe it or not, 4 years ago in law, this was kind of groundbreaking. Like, oh my God, you can access your files on your computer. Wow, that's crazy. And it just enabled us to be able to work anywhere. And so that's where the flexibility came in. Because once we were able to do that, I said, what's the point in coming to the office all the time? And I knew that the lawyers that we had working for us didn't feel like going into the office every day. Sometimes they felt like working from home. I myself was working, all over the place. I'd be working on my flights to Calgary or in airport lounges or sometimes in a coffee shop. I was always on the go. And so having all that excess office space that wasn't being used didn't make sense. And so from a business perspective, in terms of your costs and your expenses, we decided then that it would make sense to have a system of sharing offices and open office concepts where people could come in and use offices when they felt they needed them. If they didn't feel like they needed an office, they could work in a more of a common space. And we applied that principle to the work that our lawyers were doing, and also the work that our paralegals and legal assistants were doing, who were also able to work from home. And so that was seen as pretty groundbreaking before the pandemic. And then once the pandemic hit, it set us up to be ahead of the curve, so to speak. And we were able to just roll with it because those systems were already in place.
And in light of the pandemic, then in terms of all of those changes, how do you kind of balance things like, well, if there isn't paper there, in terms of worrying about all the sorts of things like privacy and data and storage and things like that? What have you kind of done to kind of offset any concerns that you or your staff or even your clients might have about information?
Yeah, for sure. So in our retainer agreements, we're very upfront with our clients that we are going to be using storage systems, cloud-based. We also have retained our own IT company to take care of that and make sure that everything's done in the proper way and securely. And when we started, we had discussions with the Law Society in terms of how to do that in the best way possible. And so we made sure that we were on board with all their systems. And so, the client understands that up front. And I think that that's part of the piece that needs to be done as well. But if you are thinking about doing that, you do need to go through your code of conduct and maybe talk to an advisor or someone from practice management, the Law Society, to make sure you're doing it properly. More and more firms are doing it. And so I don't think it's an issue really anymore. I think before it was seen as more of an issue, but given the current realities, I don't think many firms have a choice but to have offsite storage of files. The other great thing about being paperless that is quite often overlooked is storage of closed files, right? I don't have a room somewhere or a warehouse somewhere housing all of these files. Really, all I have is a file, and then the clients also are able to get their files very efficiently just on a USB stick. You just hand it to them at the end, and they prefer that, it seems, to getting like 5 binders. Here you go.
Well, that's great, and certainly the technology has come, and a lot more people are jumping on board with paperless and doing things more remotely, obviously. Now, one of the things they're coming out of the pandemic there over the last year is Coach My Case. So maybe you can first start by telling us a little bit about a background of Coach My Case and what you've done, and where did you see that need for Coach My Case and how it's filling that need in BC and Alberta.
Sure. So before going to law school and even before just going into court, I had these naive ideas that people would go into court and for the most part they would be represented by counsel. And I think that's from watching too many American, TV shows and legal dramas. But that's really not the case. I quickly discovered that in Canada, we actually have an access to justice crisis right now. It's been described as a crisis by many academics and judges, including former Chief Justice of the Supreme Court of Canada, the Honorable Beverly McLaughlin. And that crisis is that people are going in there unrepresented, and it creates not only difficulties for them in navigating the court system, difficulties in terms of their outcome, but also difficulties with the court system's processes and resources as well, because the courts, the clerks, the judges, they all have to do extra to help people who don't really have an idea or a concept of how to run a file, and you can't fault them for it. I mean, the legal rules and our processes are quite archaic and maybe arcane. They seem like black magic to some people. It's unless you went to law school and had some training in it, it can be very overwhelming and confusing. And so I saw this and thought, okay, well, there are all these people who are self-represented. I'd like to look into this issue a little bit more. And upon doing some more research and talking to some more people and reading some papers, it quickly became apparent to me that this was a massive issue. And I felt like I needed to address this in some way. And when we started up Crossroads Law, what we decided to do was put an emphasis on legal coaching and unbundled legal services, because that's one way that people who are self-represented can get some level of legal help, so that when they go to court, they can represent themselves better and hopefully achieve a better outcome. And doing that for a little while through Crossroads Law, I sort of came to understand that maybe this could work more effectively if we tweaked it in various ways and operated it as its own entity. And so that's why I started Coach My Case. And Coach My Case now is up and running. It has been since March. And what we do is we provide legal coaches who are lawyers and legal navigators who are paralegals to provide that assistance in the background with legal advice, drafting documents, or even just basic information, so that people who are self-representing can do so with more confidence and hopefully get better results. And the response has been fantastic. We've had lots of lawyers reach out who are very supportive. We've also even had judges express their support of the system as well, or I would say the business model as well. And of course, there's been, I think, interest in the media as well. We've been interviewed a number of times about it. So there is a demand there. There's a huge market. And I think more firms should be doing this. And I'd be happy to see more firms doing it.
Perfect. And it's certainly excellent there because you're seeing one, there's a backlog certainly in courts over the pandemic, and then they're just self-represented parties who don't necessarily know how to navigate the system. As much as there's some helpful guides for self-rep, it's only so much when you have very specific types of issues. So in terms of Coach My Case there, what have you seen now looking at it 6 months in? I know you shared some of the results there, but what have you looked back, anything eye-opening there about the system that you may not have thought even initially about how much this service is needed, or anything that you can kind of share from looking at it in progress since March of this year?
Sure. So the people who have interacted with Coach My Case have been really surprised and super happy that this type of service even exists. The main factor, and I knew this was going to be a factor starting Coach My Case, but the main barrier, I'd say, to getting a service like this off the ground has been the discoverability. This is not a service that many people in the general public knows is available to them. And it's something that when you tell people about it, they get really excited and they're saying, well, why didn't I hear about this before? Well, it's because I think something that hasn't really been promoted that well. And it hasn't been promoted enough by enough people. And so finding this service today with, Google and online searches can be difficult because it's something that's buried amongst a lot of other results for legal services. And so that's why I say I'd be happy for more lawyers and more businesses to start providing legal coaching, because I think once that happens, all of those services are going to see more work generated. There's a huge, from a business perspective, if we're talking aside from the access to justice piece, but just from a business perspective, there's a massive untapped market here for people that are self-representing. There's been research that's been done by the CBA that suggests that in some jurisdictions, over 70% of civil cases have at least one self-represented person. So that's quite a large number.
Now, you had mentioned unbundled services there, right? In terms of things that can be provided. And maybe you can explain a little bit more to my students about how you can kind of do pieces rather than taking on the entire matter, and as well maybe any ethical obligations as well with providing coaching, where perhaps when the self-represented party thinks, hey, how come you didn't show up to my court matter there, Marcus? I was counting on you being there. What can you do to kind of obviate any of those kinds of issues?
Sure. So legal coaching is one type of unbundled service. So if you think of the legal services that you can provide to a client as a bundle of sticks, that is the traditional retainer. You are basically in control of that whole bundle for that client. And that is writing the letters and negotiating and going to court and going to mediation and drafting pleadings and all communications and emails and everything else. That's everything in that bundle. Now, unbundled legal services is where you can take out an individual stick from that bundle. Like, let's say a person just wants you to go to court on one application. That's all they need. And so you can pull that out. Or let's say somebody just wants you to review some documents and help them draft some pleadings. You can pull that piece out. So that's the concept of unbundling. And unbundling has been something that has been done for quite a while. It's been done in some jurisdictions for decades, but it's a newer concept, I think, in Canada. But it's becoming more and more popular as a result of the fact that not everybody can afford a lawyer on one end and isn't going to qualify for legal aid on the other, right? There's this big gap there. So with unbundling, the client can have better control over their budget, over the types of services that they want you to help out on. They're not just giving you full control to do everything. They're saying, okay, I can only afford this one piece, and if you can help me with that, that'd be great. Legal coaching is one of those sticks in that bundle. And you can provide coaching by way of just providing some advice on an ongoing basis, or even in one meeting, or just by helping to edit documents, or by helping to, get somebody ready for trial, right? Those can all be different aspects of legal coaching. Now, how do you do that without getting into trouble? Running afoul of the expectations of the clients and perhaps your insurer and the law society? Well, luckily, there are lots of precedents out there for how to put together a limited scope retainer. The law societies, I believe the law societies of every province probably has a template for this. I know in Alberta and British Columbia, they do. So you can actually draft a retainer agreement that is very, very clear and structured so that the expectations are set right out to the front. You're going to be talking to your client about what those expectations are, the limits to your work, and what you're going to be doing and what you're not going to be doing. Our retainer agreements, for example, it's like a checklist, and we have numerous different things on that checklist that we could do. Just with respect to coaching. Coaching, we do not go to court, but it could be helping to edit documents, drafting documents. It could be writing letters. It could be helping with negotiation, preparing for mediation, preparing for court, arbitration, et cetera, et cetera. And we'll just check off the pieces that client would like help with. And then it says very clearly that the lawyer will not be helping you with any other aspect of your file except for those matters that are checked off above. Okay, so that's how you can prevent the problem of scope creep, which is where the client thinks that maybe you're going to be doing things that you didn't know you were expected to do.
That's great. And then how would you, I guess, deal with if they don't kind of understand that? I mean, kind of, and one of the sort of classic problems, right, is when you have clients that are wanting that help, as you say, they really need it, but got to be clear, obviously, that this is what I said I would do. We've done it, and all the best there with the rest of it. How do you kind of deal with? I mean, even in your own retained clients, there in terms of kind of knowing the boundaries between solicitor and client.
Well, you can update your retainer at any time. It's great. So if a client says, "Thank you so much, that was wonderful. I really appreciated your services, and I'd actually like you to retain you to do another piece," that would be great. And then we can just update their retainer quite easily, and they just sign a new agreement with you. Again, same process. You outline exactly what they're looking for and make sure that they're on board and have them sign off on it. So you can continually change these retainers. And with legal coaching, you're encouraged, and I think it's best practice, to check in with the client in every single meeting just about what they are looking for, exactly what they expect you to do, and whether or not you need to change the scope of your retainer. Another thing that's helpful is some training as well. There's a Legal Coaches Association of Canada now that provides legal coaching training. And all of our paralegals, for example, and most of our lawyers have taken that training because we felt like it was very important for everybody to understand these types of practical issues in terms of how to make sure there's no scope creep and practice management issues that can arise. But also issues in terms of, just general best practices with legal coaching. So if anybody's thinking about doing this, I would encourage you to get some training in that area because it's obviously very helpful. And there are some pitfalls that you need to watch out for.
Now, switching gears, one of the things, we just finished our alternative dispute resolution class for some of my students. And, after everyone gets that little bit of taste of mediation, some are thinking, hey, I can become a mediator, which is something that you do as well. Perhaps you could tell us a little bit about that experience and what are some characteristics and things that it would help out in the mediation process. And certainly you could also look at it from the other perspective of being at mediation and in terms of family law and in your practice there. What are some good techniques there that kind of help with getting through a mediation? So I know it's kind of a very heavy question there on both ends, but maybe let's start from being a mediator in the mediation sort of perspective from that lens, and then we can switch after to advocacy before mediation.
Well, I think being a mediator is great. If you can get the training and become a mediator, it's a fantastic career. It is something where you're helping to resolve disputes instead of working in the adversarial system, so to speak, and you're representing one party. It takes a shift in your mindset for sure from what you're used to learning in the majority of law school, where your duty is to a client, a particular client. But as a mediator, you don't have that responsibility. Neither client is your client. You're just the mediator. You can't give advice to either one of them, and you have to stand back and just help them in the process. It's not the mediator's role in my experience. It's not the mediator's role to come up with a solution. That's really up to the parties. The mediator facilitates that discussion, and the mediator controls the process, and the mediator may give options. But at the end of the day, the parties control the outcome, and they control the solution that they come to. So I think mediation is fantastic if that's a career you're wanting to pursue. And it is very different than looking at a case from an advocacy perspective. Now, that being said, I also really enjoy being an advocate. I'm passionate about it, and there's certain cases and causes out there that I want to advocate for. And so for me, I like having a balance of both. And I have a practice where I'll mediate, but I will also take on very litigious files with, long trials, and that's because I enjoy both of those things. So I think that's possible, and you can do that. In terms of the practice of mediation, I think that was your first question. I think I answered that, but the second part was when you're in mediation, what are some of the things that you can do or think of, or things that are important? Well, I think taking the training on mediation is really important, for one. Mediation has changed a lot, probably in the last couple decades. The real focus now is on interest-based negotiation and really looking at what the true values and interests of people are and coming to a solution instead of just a positional sort of bargaining. And for many areas of law, that's a very important perspective to take, especially in family law proceedings. When you're dealing with issues that you can't just quantify and turn into numbers, you need to have that interest-based. You have to have that interest-based type of mediation process. And it's amazing what you can achieve if you really dig down to the interests. Because I think initially people go into these discussions, and I see it all the time, they go in there thinking that they know exactly what they want out of this. But at the end of the day, when the mediation is done, they've come out with something completely different that they didn't expect. And they're happy that there has been a solution, a creative solution based on their interests. So that's one of the key components. Another little tidbit, I think, from mediations that I find really helpful is that quite often you're in there and your client may say, there's no way we're going to get to a solution because the other side is just completely off the wall. They're never going to be agreeable. They're super litigious and they're so mad at me. And I find that many times when you get into the mediation and you just let the parties speak, sometimes that's all they wanted. Once they speak and they have an opportunity to tell the other side what they feel and how everything impacted them, sometimes everything else is easy. Once you get past that, all of a sudden they're agreeable to all sorts of things. So mediation is really interesting. It's great that the students in your class are getting the training on it. I think that it's the best way to go for the vast majority. 95% of cases out there should be resolved outside of court. And in fact, I think that the actual number of cases that are resolved outside of court is probably about 95%. It's not, most of them do end up being negotiated or settled way before court. And so for my practice, I always tell people that the best way to start is by trying to resolve things on your own if you can. And if you can't, then a lawyer can help you and then try out the mediation process first before venturing down to court, because you're going to save a ton of time. You're going to save a ton of money. And at the end of the day, you're going to have an outcome that you're probably going to like more if you have control over that outcome.
That's great. Certainly with mediation there, you have your ability to have influence on the outcome, whereas at trial in litigation, whatever the judge decides, obviously based on precedents, may not be what you were expecting, and obviously the cost and time that goes into that. Now, I mean, we talked about mediation there in the sense, of all of those concepts there, but looking at it in terms of practice over the last year, and this maybe not necessarily just about mediation, but all other areas of your practice, how are things been done out in BC, and what sort of are things returning to in person? And maybe you can share from that perspective and any advice for students who might be going into a world where remote hearings and set dates and preliminary appearances are going to be the norm going forward. What can you share and give any advice about how to conduct and handle things remotely, whether you want to use mediation as example or anything else that's different compared to being in person and being in the courtroom or being at a hearing?
Well, I think that more cases are returning to in person, but I also see that many of them are staying remote. And I would be very disappointed if we went back to the system that we had before. In fact, there was a CBA research paper done this year called No Turning Back on this topic. And it's about the changes to the justice system as a result of COVID and how many of those changes have been very positive. And one of the positive changes is being able to access courts remotely. Not only is this positive because it's more efficient for your regular litigants and more efficient for the lawyers, but it's also a positive for people who have access, mobility issues rather. It's also a positive for people living in rural communities who may not be anywhere near a courthouse. So I think that we should maintain these remote hearings to the extent possible. In my opinion, we should probably be doing them for all chambers applications. And I'd be really disappointed if we go back to the way things were. In terms of the some tricks to do remote hearings. So I've had many applications done remotely. I've done many morning chambers applications remotely. I've done full day chambers remotely. I've done multi-day trials remotely and multi-day arbitrations remotely and multi-day mediations. And so I think that it works for all of those types of venues. Now, what you can do, there are some things I should say that you can do to make it easier. One little trick that I have is that I have purchased a massive screen. You can't do it if you're working on a laptop. Okay, don't try doing it on your iPad. Get a huge screen, okay? And if you can't get a huge screen, get like three. I'm looking at 3 screens right now as I'm talking to you. And then in my home office, I have this giant curved screen. And I do that because I can put the Zoom meeting images right in the center, right below my camera. So I'm still looking at everybody, right? I'm talking to you right now. I'm looking at the camera. I'm not looking off like this, right? It's sort of distracting and you don't have the connection. But at the same time, I have all of my documents that I'm relying on up and ready to go. And when I want to start reading them, I'm just going to grab one quickly and I just drag it over and drop it right below your image. So I'm looking at it right now as we're speaking, but I'm still facing you. And so for court, it's really important to maintain a connection with the adjudicator. And it's important, I think, to be looking, if not at the camera, but at least in the general direction of the camera, because otherwise I don't think you maintain that connection very well. So that's one little trick. The other trick is get good lighting. Okay, don't be the person in court who's fully backlit, sunny day, looking at the camera. You're just a silhouette. Not effective. Okay, and if that's your setup, like I've got a big window behind me with a great view. But if I didn't have a light here facing me, it would completely be dark. You wouldn't be able to see any of my features. It would just be all light back there. So you have to think about that as well. You want to project professionalism, and that's one way of doing it on these Zoom calls.
What about in terms of just advocacy itself? I mean, they've moved on actually from alternative dispute resolution into advocacy. And as you go to those first kinds of mock trials or just your first real trial, any advice there in terms of getting ready in terms of delivery? You don't want to be like a deer in the headlights when the judge calls on your name there to make some submissions or to start with direct or cross-examination. Anything there from your experience there in getting ready for trial and delivering at trial? for those 5% of cases that make it there, but seem to be 99% of what's on US television there.
Well, luckily, we're not quite as litigious as they are in the United States. But yeah, I mean, obviously, practice. You do it. The more you do it, the better you get at doing it. If you can do some mock trials, I think that really helps. I really think that more students should be doing hands-on in-court training. When I was at the University of Calgary, we had a program called Student Legal Assistance, and I spent most of the time in that clinic providing legal advice to clients. And that clinic also was able, through an order in council in Alberta, to send students down to court, even in Queen's Bench, to deal with, provincial court, to deal with hybrid criminal offenses. And so we were able to get down to court on all kinds of interesting things in advance of actually graduating law school. The other thing that I think is key is just your mentality, right? What mentality do you have going into court? And one thing that I tell young associates and articling students quite often is that you have just as much of a right to be in that courtroom as the judge. You have a right to be there. You have a right to say your case and be heard. And you go in there knowing that you have just as much of a right to be in there representing your client as anybody else. And so, try and go in there with that mentality if you can, because I think sometimes, students or people who aren't used to it, they go in there, sheepishly feeling out of sorts and out of place and like they don't belong. But everybody has a right to be in there. So take that for what it's worth. And aside from that, though, definitely try and get as much experience as you can.
Great. And I think certainly as well for my students there that have their mock trial, the ability there to have multiple screens, or making sure you can bring the exhibit or whatever you're going to bring up and put it kind of right below you, as you said. I think that's excellent that you can keep that eye contact rather than spending half your trial looking, off into the side there, especially when you're doing questioning. Now, have you found, I've gotten like a mixed response from all the lawyers over the year and a half year about this type of question. I don't know, maybe if you can share your experience, but how have you found doing any kind of questioning or cross-examination of a witness? Do you feel, some have expressed, concerns that they might be using stuff off camera or things like that, and is it as effective as being in person? Or others have shared, well, they don't have that concern because obviously they're swearing, on, or they're affirming, and it's no different than being in person. And anything to share from that kind of perspective?
Well, I don't share the same concerns. For me, it's been quite effective. Done a number of discoveries by Zoom and cross-examined a number of witnesses by Zoom as well. I think that it's great. You can blow up the image as big as you want to see your witness, really focus on them, and you know that the judge is going to be doing that as well. In terms of them reading other documents, and having pre-prepared answers. I think that becomes evident very, very easily and quickly when someone is doing that. I mean, you can really tell, especially if you're asking them, some rapid fire questions, and if they're, looking all over the place on their screen and struggling. I actually had a judge call somebody out for that and ask them if they were reading other documents, and they're like, "Oh, no," and you could see them panicking. So I think that it still works really well in terms of assessing somebody's credibility. At least that's a feeling that I have so far, doing it a number of times. Now, is it as good? Is it as good as being in person? I think that probably being in person is a little bit better. I do. I mean, having that individual in front of you and really being able to take in the room and the feeling that you get from everybody, you can't replace that. But doing it by Zoom is still pretty effective. I'd say very effective if done correctly.
kind of by analogy, it's like with the all the sports when they were playing in their bubbles and there was no fans, and then all of a sudden you have a packed arena, and it feels like it's completely different, but at the same time, it's the same thing that's being played, in the rink or on the court. I see a question here from one of the students about I think it's PS parental. I believe it's parental alienation. I don't know. I'm not so familiar with the acronyms. Um, are you finding, in terms of people trying to get representation for these type of cases in BC, and do you do any of these types of cases? I don't know if you have anything you can share about that.
Yeah, I definitely have had numerous files where there has been concerns of parental alienation. They're some of the most difficult files to deal with, and I mean, that could be a whole podcast in and of itself. I'm not sure what the question is, but definitely that's a big concern in family law matters. And if you do have a case with parental alienation, you need to move swiftly. Quite often, experts are going to be necessary. Of course, there's a lot of he said, she said in all cases, but it's particularly important in those ones. And you also have a child who may or may not be old enough to express some of the issues that are happening in the family, maybe express some of their preferences. And so quite often we'll retain experts to assist with that, because it's inappropriate in the vast majority of cases for the child to actually give evidence. And so you need to do that through a what's called a voice of the child report, or a hear the child report, or even through a psychological assessment done by a psychologist who will speak to the child and the parents as well. So those cases can be very complex, and quite often very unfortunate. I mean, even if you're successful, it doesn't mean that the client is ever going to have a normal relationship with their child, especially if the child is older, right? Especially if the case takes years, and by the time it's done, the child is 15 years old or 16 years old, and you get an order saying, yeah, parental alienation happened. But what can the court do at that point, right? Is the court going to drag the child to the other parent's residence, or send the police to arrest them and have parenting time? So those cases can be very very complex, and pretty emotional for everybody involved, including the lawyers, who can get really wrapped up in those types of cases.
It's a great point you mentioned there, as well as the lawyers. I mean, how do you kind of deal with, for those practicing in areas like family law, criminal law, where you have so much at stake, and the emotions there, and how do you kind of deal with all that, and be able to do your job and be objective to your clients, and as well take care of your own mental health? I mean, anything that you can share with young paralegal students here and others listening, in terms of who may want to get into this profession, how to kind of find that time for yourself, so you can, if you take care of yourself, then obviously you are better equipped to take care of your clients.
Right. Well, I mean, I think that there's perspectives that you need to take in your practice. You can't take things personally. Like, they're not your issues; they're your clients' issues. You're helping your clients with these issues, right? That's one thing you always need to remember. So you can't become too personally invested. I choose not to build up friendships with my clients for that reason. I make sure there are boundaries there, because I don't think that you are going to be as effective if you do have close relationships with your clients. Also, I think that it's important to remember that you should always be attacking the issues, right? Attacking the issues and using the law to do that, not attacking the parties, not attacking counsel, right? Let's keep things professional at all times and focus on those issues. And let's not, get into ad hominem attacks on the individuals on the file. In terms of work-life balance and what you can do to take care of yourself in the practice, there certainly are some areas of law which are more stressful than others. Family law being one, criminal law is another. Estate litigation, that's a very emotional issue, or emotional area as well. In these areas, I think that it is really important for lawyers to recognize their own needs in terms of their psychological and emotional well-being. And for me personally, what I do is I try and make sure that I'm exercising as frequently as possible, because that helps deal with stress. I also try and make sure that I'm always getting a good night's sleep. And sleep is really important. And also make sure that you take time for yourself, right? Take some holidays. Make sure that you carve out some time in your schedule to do that, because you need an opportunity to disconnect and truly disconnect. Also, another great way of doing that is to set those boundaries with your clients that you're not going to be responding to emails after hours. You're not going to be responding to emails on the weekends. If I work on a weekend, it's because I feel like I need to be prepared for something that's happening the next week, maybe a trial, but it's not because a client is demanding that I get back to them on the weekend. I have boundaries regarding that. So I think that those are important as well.
I see another question here about legal coaching versus just representing the client. Have you ever found that sort of going through and coaching through the process and what the next steps are, required more resources or time than just representing the client on the matter yourself?
Well, yeah, I mean, that happens all the time. And clients who are in a coaching arrangement, if they decide that the coaching isn't enough, then they can be transferred to a lawyer who can work on their file in a full retainer capacity. And that does happen. It happens quite a bit. So that, I think that that's something you need to expect is going to happen. Remember that legal coaching is a practice that is client-centered, all right? And the client really, if it's a true client-centered practice, the client should be responsible to a great degree in terms of how they want their matter to proceed, whether they are going to be using you for one meeting or editing a document, or if they feel over their heads, then maybe they need a lawyer. And the lawyer's job is to be checking in with that client to see what they need, right? And to try their best to reduce the barriers as much as possible for the client to get the services that they need going forward. So for us, it's all about trying to make things as efficient as possible for clients. That means accessing the lawyers or the paralegals in Coach My Case. We want to reduce barriers to that so people can access us remotely whenever, by email, by phone. We don't have even a physical office space. Everything's done remote. People aren't expected to come down to the office to do anything. Also, everything's electronic, as I said before. We don't have paper files. And in terms of payment, there's different ways that you can do that to make it as easy as possible for clients as well. Also, we provide a lot of free resources for clients on our website, places that they can essentially like lists of different links so that they can help get up to speed in the area that they're working in. We also are providing blogs and information on a regular basis. And if somebody feels like they need a shift in the services that they're getting, if they need to be transferred to another lawyer, if they start with a paralegal and they want to go to a lawyer, if then they want to get escalated up to a lawyer to represent them, then we make that available because, I think that that's the best way to do it, right? We don't, I think law quite often is a profession where we rely on our precedents in terms of how we've always done things. And it's certainly because of that, I don't think we're the most client-centered type of business that we could be. If you look at other businesses that are really succeeding right now, they are ones where they are reducing barriers as much as possible, making things as easy as possible, right? You look at businesses like Spotify or like Netflix or like Uber. Sort of the hallmark is to just make it as easy as possible for people to get the stuff that they want. And I think we need to think about it the same way and to some degree for law. Otherwise, I think that we're going to just be left behind because I think there's a massive push right now on law societies from the government to make services more accessible, to reduce the costs. And if we don't change our processes and services that are available to clients. I do think that it's going to be done for us, and we may not have a voice to be able to do that. And I think you see that pressure across many different provinces. I know in Ontario now you have paralegals who can represent people in court, which I think is fantastic. I think that that should be done in more places. So I guess that's a roundabout way of saying that I think we need to think a lot more about how to be client-centered in our practice and meeting clients where they are to meet their needs.
Perfect. So Marcus, thank you so much for taking the time here and joining us today. Any last words of wisdom here for students looking back maybe from your own time as a student and as they make those steps getting into the profession and succeeding? Anything you can conclude with sharing? And thanks again for joining us.
Yeah, sure. So for all the legal students out there, just remember that law is it's a big area, right? You don't need to take a traditional career path. There are many different career paths that are presently available. And given the way things have been changing, I think there are many opportunities to create your own career path as well. So don't feel pressured to, grab the first big corporate, big law job that becomes available to you if you're not really passionate about that. There's many different options out there. So that would be sort of the general advice for anybody. And like I said before, as much as possible, if you're going to be an advocate, if you're going to be going to court for people to any extent, try and do some work in the legal clinics that are out there in your universities.
Perfect. So thanks again. And I think earlier you'd mentioned you wanted to go and make change in the profession. And so just wanted to end here with congratulating you on being selected as one of the top 25 most influential lawyers, I believe, under the change-making category. So what you had set out there, at least congratulations on accomplishing that and all the other things you're doing. It's tremendous, and all the best. And thanks again for joining us.
Yeah, thank you. Thanks for having me. Really appreciate the time to chat with everybody. I think you're doing a great thing with this show as well. I know that there's law can be a big, confusing and scary area and overwhelming. So I really appreciate what you're doing as well to educate students and also the public on legal issues.
Perfect. Thanks again, and all the best. Take care, everyone.
Thanks, Jean Paul. Okay.